a little bit about. I'm very happy to be talking a little bit about children and families across borders and our work in international kinship care. I'm going to go ahead and share my screen with you and begin our presentation. And of course, if you have questions, please do put them in the chat box and I will look to answer them towards the end of the presentation. Right, so, there we go. Over the next 45 minutes or so, I'm going to tell you a little bit about who Children and Families Across Borders is, also known as CFAB. Why are we talking about international kinship care? Why did we issue an international kinship care guide? And what do we consider to be good practice? And specifically, I'll be looking at pre-proceedings, court proceedings, permanency planning, post-placement planning, and special challenges. And I will do my best, of course, not to use acronyms or any language that may not translate well into other languages. But in this field, there is a lot of technical language. So if there's anything that you don't understand, please do flag in the chat box, and I will try to explain it. So who is CFAB? Well, we are a charity that was previously known as International Social Service UK, and we changed our name to Children and Families Across Borders in 2009. We are still the UK branch of International Social Service. We were established just after World War II. We're the only NGO in the UK or non-governmental organization in the UK which specializes in the provision of inter-country social work. So we've got an international social work team, and we provide assistance to vulnerable children in public and private law cases. So that will be cases where a child has been taken into care by a local authority or government agency, but also cases where the local authority may not be involved. So it might just be that, for example, parents are not able to care for a child or something has happened and they want their sister, the auntie, whomever it might be in another country to look after their child. I mentioned that we're the UK branch of International Social Service. ISSA is a network that was established just after World War I. They provide assistance in cases involving vulnerable adults and children that are crossing borders. They're present in 120 countries, 130. It's growing every year, of course. The General Secretariat is based in Geneva. And it's important to know that within the ISS network, there are charities just like CFAB, but there are also government departments, ministries of justice, ministries of social welfare, central authorities, as well as independent social workers. So it's a real mix across the network, meaning that we get to benefit from different types of expertise and different experiences. So in terms of CFAB ourselves as a charity, there's a number of different services that we provide. We have a free advice line that is staffed by social workers 5 days a week. And at the end of this presentation, I'll share the advice line number with you. We get around 2,000 calls a year from social workers in the UK and in other countries, from health professionals, from police, from lawyers, and from private individuals, so family members who are concerned about a grandchild or a niece or nephew. About 75% of those calls, we are able to provide advice and refer on to other organizations. Otherwise, we may take on cases ourselves. So within that casework, we do child protection alerts. So that may be where a child is believed to have gone abroad and there are child protection concerns. We get in touch with the corresponding authorities overseas to make sure that that child can be located and confirmed as safe. We do welfare visits to check up on children who are settling with new carers. We do social service and police record checks. That usually is before undertaking an assessment of a potential carer. We do the full assessments of course, as well. So kinship assessments, special guardianship assessments. We offer something called local assistance. So there is a trend sometimes of social workers going overseas to practice and do assessments themselves. That isn't something that we suggest happen. We always say that social workers in the UK should work with social service professionals on the ground in the destination country. However, sometimes they do go overseas, and when that happens, we try to connect them with local agencies so that they understand local context, they understand local legislation, what neighborhood they're going to. They get a better sense of the culture and environment that they're in. We do post-placement services, so checking up on children after they've been placed with a carer, training in the UK of social workers, as well as training overseas. And of course, underpinning all of this is research. And I'm going to tell you a little bit more about our research in a moment. And just to let you know, in terms of the wider global ISS network, there's a number of other services that ISS offers, from international adoption to tracing, surrogacy, family mediation, child abduction, and moving children with disabilities to family care settings. So if that's something that is of interest to you, I encourage you to get in touch with the ISS Secretary General in Geneva. Right, so why did we develop an international kinship care guide in the first place? Really, all of this is underpinned by the fact that we have been doing international kinship care for 65 years. And throughout that time, we've noticed that there's a real discrepancy in practice across local authorities and across countries. So in 2018, we decided to do an audit of 100 of our international kinship care placement cases. And in that, we found that 1 in 3 of those cases resulted in an international placement. Now, it's important to note here that in 30% of those cases, we couldn't actually follow up and check whether the child had been placed or not. So actually only 2/3 of those 100 cases we had outcomes for. So if you remove the cases where we didn't know the outcome, it's actually as high as 50%. So the international placement rate was as high as 50%. And really the point that I want to make here is that international family placements are absolutely viable options for children. We always believe that children have a right to their family, and that family should always be explored no matter where they are in the world. And increasingly, we're finding that this is a viable option for children. There's no reason for them necessarily to be put into foster care or to be put up for adoption when there are family members in other countries that could care for them. In terms of some of the other research findings that we had, we found that there was a risk of placement breakdown, but often this placement breakdown could be prevented. So the reasons why we were seeing placement breakdown when a child had been placed abroad might be because the UK court order wasn't mirrored and the parent tried to remove the child. So if the child is placed, very frequently, you'll see in the UK, a child will be placed in another country on something called a special guardianship order. Now, in most countries in the world, a special guardianship doesn't exist. That's not something that's frequently used. And then that court order isn't mirrored or reflected in the destination country, which means the legality of the placement can be challenged and the parent could come back and try to take the child. We also saw instances where the carer was unprepared to manage the child's challenging behavior. Now, again, we have to remember, most of the time we're looking at children who have been removed from their parents' care because the parent has been abusive to them, neglectful, maybe they're suffering from mental health issues, there may be substance misuse issues, and that is obviously very traumatic for any child. And they've then been placed potentially with an unrelated foster carer, taken into local authority care, and then they've gone to another country to be placed with a family member that they may not have seen for a while. So this is a very traumatic journey for any child. And it is really important that that carer overseas is prepared to support that child and the needs that they may have, emotional, psychological, physical, whatever the case may be. But often support isn't given to the carer prior to the child's arrival. And that meant that sometimes the placement would break down. Sometimes carers struggle to apply appropriate boundaries and contact between the child and parent. So this could be particularly true where a child is placed with a grandparent. And then that grandparent is struggling between trying to protect and care for their grandchild, but also to set boundaries with their own child, so the mother of the grandchild. And that can be very challenging. And again, if support isn't provided to carers on how to manage contact, it can present problems in the placement. Also, a big takeaway from the research was the sheer variation in quality between local authorities and their knowledge and their resources and in the level of post-placement support offered and the overall approach to assessments by organizations that came to us. Local authorities are doing things differently throughout the UK. There's just over 200 children's services departments throughout the UK, and each one takes a different approach in terms of whether they will consider a family member abroad, how they conduct that assessment, what support is given to a carer prior to the child's arrival, what support is given to the carer after the child is placed. And of course, this can impact significantly on the success of that placement and whether the placement breaks down. So keeping this in mind, and as I say, all the different practices that we've seen, the good practice and the not so good practice, we felt it was really important to create an international kinship care guide that constitutes good practice, that takes a social service professional through the various steps that need to be considered if they are considering placing a child abroad with family. Now, this international kinship care guide can be found on our website on the resources page. It's right at the bottom of the page, so I've circled it there for you if you do want to go to our website and find it. It is a very comprehensive guide. It's a great thing for you to just look through when considering placing children abroad. And of course, as you can see there on the screen, we have a number of other fact sheets and support material for social service professionals, and they're all free to download. So please do take a look. So let's turn to what good practice looks like and what social service professionals should take into account when looking at various stages of placing children abroad. Now, I mentioned earlier that it's important to talk about definitions of things, and there's quite technical language that's used in social services, at least in the UK, and it may not translate as well in other countries. One of the issues that we found is that kinship care, for example, is defined differently in different countries. And it is also worth remembering that our international kinship care guide is really designed for an English audience. So a lot of the terminology used within it is going to be relevant for England. And I've noticed that I'm using the word, England and not the UK. Some of the stuff in that guide won't even apply necessarily to Scotland, for example, or Northern Ireland or Wales. So again, understanding terminology and how it might differ across nations and countries is important. In terms of our guide, kinship care is a term used in the United States and the United Kingdom for raising of children by grandparents, other extended family members, and significant others with whom they enjoy a close family-like relationship. So it could include friends of family, for example. Kinship care placements are usually considered when a parent is not able to care for the child, and it may be a permanent arrangement, usually formalized through a legal order. I mentioned earlier the UK often uses a special guardianship order to place children with families, with related family members. It's usually used when parents, as I say, are not able to care for the children, and it may be a temporary or informal arrangement made privately amongst other family members, often initiated by the parent. So at the very beginning of this presentation, I mentioned sometimes we see private arrangements where parents aren't able to care for a child, and so they ask an auntie to take care of the child for a while, and that's an informal arrangement. Our kinship care guide follows the steps that you see here on the screen in terms of placing a child abroad. This is generally speaking the same sort of process that a local authority would take when looking at placing a child with a family in another country. So first, the local authority would identify prospective carers and confirm their nationality and immigration status. The local authority would inform the relevant consulate if there's no risk to the child of doing so, for example, with asylum seekers. Then a UK court would determine habitual residency to consider appropriate jurisdiction. For example, if England has jurisdiction, the court may make an order for kinship placement abroad and would need to seek permission through Article 33 of the Hague Convention 1996, if that applied in the receiving country. And this is what will enable the court to ensure that the order is recognized and enforced in the destination country, in the receiving country. And of course, the court and the local authority should always ensure there's a comprehensive care plan to support the placement. So I mentioned before some of the reasons why placements break down and why it's so important to support carers when they are taking on a child. Now, some of you may already be familiar with the Hague Convention 1996. I've put up on the screen for you those countries which are contracting states to the Hague Convention. This means that there's a central authority that is set up in those countries to cooperate on children and families issues and child protection matters. It also means that orders that are made by a court in any of these countries should automatically be mirrored in the destination or receiving country, but that isn't always the case. It does depend on which country it is, and so it's always really important to make sure that the family that's taking on care of the child receives legal advice and understands how to ensure that that placement is legal in their country. All right, I'm going to move on to pre-proceedings, which is really the first step on this journey. Citizenship is something that's really important to consider. It should not be assumed that citizenship is based on where the child resides or where the child is born. So even if a child is born in England, in the UK, it doesn't mean that they have British citizenship. And they may not necessarily have citizenship based on the mother or father. So, it is really important to follow this up. The relevant embassy or consulate should be consulted at the earliest opportunity so that all necessary documents, birth certificate, passports, copies of parents' passports can be obtained in order to confidently ascertain the child's citizenship. Data protection concerns will need to be considered in this process, and determining the child's citizenship is incredibly important at this early stage, as it will help determine the immigration status of the child, both while placing them overseas and beyond their placement. So will they have the right to remain in the country even after they become an adult? They may have the right to remain in a country if they're the dependent of the carer that's in the country, but once they become independent, do they still have the right to remain? This will also help to determine their entitlement to any local statutory services for their child and for the carers, as well as which type of assessment would be required for that placement. In line with this, the immigration status of the prospective carer should also be checked to confirm their own status within the country where they reside and any impact on the child's subsequent status. So sometimes we've seen placement of children with carers in a particular country, but actually the carer's immigration status isn't settled, which can be quite disruptive if the carer then has to return to their home country, wherever that may be, and it's not certain that the child could necessarily go with them. Overseas social service record checks and police checks of the potential carers are also best undertaken during the pre-proceedings, as the process for obtaining these may be lengthy and not possible within the short court timeframes within the UK. The initial screening assessment gives an overview of what the overseas family can offer in terms of care and can include an analysis of risks and strengths, as well as options for support needs, in order to inform a further full assessment. But it often will not be sufficient to gauge the overall viability of that family member and whether they are prepared to be the carer for this child. It's also important to consider whether or not that potential kinship carer is entitled to legal aid and can be party to any court proceedings should they happen. And they should receive legal advice from a lawyer who can advise them on English law, if that's where the court proceedings are taking place, but also how they can ensure that their order is legally mirrored in their own home country. So there's quite a lot to do before the child's case even goes to court. Then we come on to proceedings. So this is when the child's case is being heard before a family court judge. Now here I want to again note a couple of different terms. We use the term full assessment or kinship assessment interchangeably to cover all types of complete assessments for an overseas carer. And this is really about determining the suitability for care of the child in the UK. And that's different from the viability assessment that might happen in pre-proceedings, which is more of an initial check to be able to rule out a potential carer based on basic information. But if they pass that viability assessment, you would then move to a full assessment. Now, whilst the most effective and recommended method of obtaining an assessment is to seek contact with a social worker based in the country of the potential carer who can perform the assessment, there are other ways this can be achieved. But these all come with caveats. And so I mentioned earlier, sometimes we see in the UK that social workers will fly to another country to complete the assessment themselves. That isn't necessarily something that we recommend, because it can mean they miss a lot of cultural nuances, local context, and in fact, it may well be illegal for them to practice social work in that country if they need to be a registered social worker, etc. Another example could be a joint assessment. Another example could be a split assessment. So that might be where a local social worker goes to the carer's house and does a home visit and perhaps writes up a report on local support infrastructure and school and neighborhood and support plan for the child, etc. At the same time, the potential carer might fly to the UK. And the social worker in the UK might assess that carer in the UK. A joint assessment might be where a UK social worker and a local social worker undertake that assessment together, so they're able to complement each other in terms of knowledge. The UK social worker, of course, knows what the UK court needs to know, whereas the local social worker will be able to advise on, cultural context and, what is common practice in a particular town or village or neighborhood or religion. Of course, depending on what the country is and how familiar it is to the UK social worker. Again, in terms of traveling abroad, I've already said that, it can be fraught with difficulties for a UK social worker to go abroad to practice. They need to have the correct permissions. They need to potentially have work visas. They need to ensure that they've got insurance to travel abroad. We found that it can be quite disruptive for the family to have a foreign social worker come into their house and assess them, particularly if you're talking about small rural villages. It can cause quite a lot of talk locally, and it can be risky, unethical, and sometimes illegal. So that's something that we would advise against. Then we move on to permanency planning. So whatever support is offered, once the placement is made, it should be detailed in a permanent placement plan. And there should be an agreement as to the duration of support, including a mutually determined cutoff date, which is suitable based on the child's needs. So you can imagine that if a child is placed from the UK to another country, the UK local authority may wish to support the carer, but that support isn't going to be indefinite. It needs to be quite clear, when that support is going to end, and how the carer would continue to provide support for the child on their own, or if the child has become an adult, they would be independent. There are currently no legal requirements which determine the length of time for the UK local authority to retain responsibility for the child after the placement is made, and there are no really clear legal requirements around what support should be given to overseas carers. In the absence of these requirements, it is good practice to agree a time period which should give sufficient time for both the child and the carer to settle into the placement, but also to identify any additional challenges or needs. Contingency planning should be executed between the UK local authority and the receiving authority in which the overseas kinship carer resides. This should aim to make provisions for which authority will take responsibility if the placement should break down. So we've seen examples where a child's been placed abroad and that placement has broken down, and the foreign authority puts the child back on a plane and sends them back to the UK with no one to greet them, nobody necessarily taking responsibility for them. Obviously, significant risk to that child. So really, we need both authorities agreeing on what happens if the placement breaks down. Consideration should also be given as to the social service system of the receiving country, and assumptions should not be made that the country has a robust child protection system which will safeguard the child if the placement breaks down. So that's something that needs to be taken into consideration. Many countries only have systems that operate for their own citizens. So again, establishing the immigration status and nationality of the child is really important to understand the rights and entitlements they may have when going overseas to live with a carer. Where a child will be placed in a kinship care arrangement overseas, or where the overseas local authority intervention will be required in relation to the placement, consent must be sought from the competent authority in advance through the Hague Convention 1996. Again, this is for contracting states of the Hague Convention. Local authorities are meant to notify the receiving country and the competent authority that that placement is taking place. Without that, sometimes the receiving country can say you didn't follow the proper procedures, child is being sent back to the country of origin. So really important to be clear on the legal processes under the Hague Convention. Post-placement planning should be undertaken and considered as part of the placement plan itself and conducted prior to the child being placed. Local authorities should liaise with local professionals, either statutory or private, to request that a post-placement visit is completed in order to identify additional support needs by the carers or the child. Now, this is something we don't see happen too often, but it is really important. If you consider all of the challenges that a child faces, even within a domestic setting, if they've been removed from their parents' care, they've been put into potentially unrelated foster care, they've witnessed whatever they've witnessed, whether it's a form of abuse, whether it's substance misuse, etc. A child, has had a very traumatic journey. If they're then going overseas to join a care that they haven't seen for a while, if at all, that is also particularly challenging. At least doing one post-placement support visit to ensure that that child is doing well and to identify any additional support needs. It's really important. These visits should take place at least during the settling in period, if not ongoing. And post-placement plans should include information on maintaining contact with whomever the child knows in the UK, such as half-siblings, parents, close friends, etc. It should also detail how these contacts should take place. Who should have contact with the child? So in some cases, it might not be appropriate for a parent to have contact with the child. How frequently? Through what medium? Is it a phone call? Is it a video chat? Are they coming? Are they flying overseas to visit the child? Where are they staying? Again, how is that contact being managed? Planning should also be undertaken, which prepares both the child and the family for the actual placement itself. There are several things to consider, including who should accompany the child when they travel overseas, depending on the circumstances and depending on what is deemed to be most comforting for the child. Children's Services departments may wish to ask the approved carer from overseas to come to the UK to collect the child and take them back with them. Alternatively, it might be best for the UK social worker to accompany the child when they go overseas. The aim here really needs to be about reducing shock, uncertainty, and nervousness that a child may feel whilst moving from one country to another and potentially staying with an unfamiliar carer. Further consideration should also be given to how to introduce the child to the family members that will be taking care of them. This again will be contingent on whether the child and the carer have already met and whether they have an existing relationship. In order to facilitate a smooth transition and in the best interest of the child, it is best practice to ensure they have contact with the prospective carer as soon as possible so they can start building that relationship at the earliest opportunity. At an early stage, specialist legal advice should also be sought about recognition and enforcement or mirroring of the orders in the country to ensure that if that child is placed abroad, that the placement is legally recognized. Okay. So on to post proceedings. Again, here, this is where the practical arrangements need to be considered, including transport, accompanying the child on the journey overseas, who is greeting the child, whether an interpreter is needed. We do see children who have been, been raised in the UK, who speak English, joining family members, for example, in France, who only speak French. So how is that initial contact going to be managed? How is that relationship going to be built? What support can be given to that child and the family to ensure that they settle in well and establish a strong bond with their potential carers? This final section is really about special challenges. And some of these challenges are not necessarily unique to an international placement, so you may see them domestically as well. But the international element can add a level of difficulty. It's important not to assume that the receiving country does not have appropriate resources to support a placement. So far I've been talking about what support can a UK local authority provide to an overseas family. But of course, that family may be benefiting from quite rich resource support network in their own local country. But that doesn't mean that care should not be taken when assessing a child's developing and potential complex needs and whether there are resources available that will provide support, particularly if it has been identified that a child has specific needs, whether that's medical, behavioral, educational, or related disability. It should be identified if the country and the local area in particular has sufficient support and resources to meet those needs. If a child has any disabilities, including learning disabilities, the extent to which the carer is able to support the child with these should be considered, and specific support plans should be put in place which identify and respond to those needs. Consideration should be given as to what the education system is in the country and how it is accessed, etc. Consideration should be given with regard to how the carer intends to develop a good relationship with the child who they may have never met. And this can be addressed initially through a good quality and highly detailed transition plan. Consideration should be given with regards to likely differences in culture, languages, practices the child might not be used to in the receiving country. And similarly, consideration and planning should be executed to ensure that the child's existing identity is maintained and supported by the new carer. So that's really about ensuring that whatever the child has experienced, where they've grown up to date, whether that's in the UK or anywhere else, that level of knowledge and attachment to the country is maintained even when they go to a new country, so they've got a strong sense of identity. These differences highlight the importance of local collaboration and having contact with social workers in the local area who will usually be better placed to identify these differences. It is important with regards to culture to also consider the limitations and involvement with certain practices. For example, some cultural differences, such as the preference of not engaging in physical affection, hugging, hand-holding, might be upsetting for the child, but these are differences which can be ironed out with a good transition plan to make the carer aware of the child's preferences. In the UK in particular, we've got the Foreign, Commonwealth and Development Office, which regularly issues guidance on local laws and customs in every country. So that's a great source of knowledge. And this also includes various levels of tolerance to people in the LGBTQ+ community and other laws to be aware of if a child has a UK resident or national, and they might be put in danger in that destination country. The child's wishes are incredibly important when it comes to religion, and there are a range of nuances that the carers and assessing social workers should be made aware of. For example, carers overseas may practice their religion differently to the child's experience, or indeed, carers may hold an entirely different religion to that of the child. Consideration should be given with regards to the country's attitudes and laws towards gender. For example, if the country has a particularly large gender equality gap, how might this impact on a female child's opportunities in the medium and long term? Does the child's gender inhibit their access to education? Are there local variations? So the national law might be quite robust, but actually practice in a local village may be very different. The same sorts of consideration should be given to the LGBTQ+ community and whether the child's safety or access to support might be compromised due to their sexuality. Again, other risks such as FGM or forced marriage also need to be taken into consideration depending on the country and the gender of the child. At an early stage, advice should be sought about the child's immigration status and travel documents. If the child understands the implications of their immigration status on the nationality rights and travel, etc., then they should be consulted. It is important to ensure that the child will have a permanent status to reside in the country where they are placed before the placement is completed. If the child is a foreign national who also has entitlement to British citizenship or might return to the UK, for example, if the placement breaks down, there's a need to ensure that the child will be able to re-enter the UK. So again, those immigration issues are really important to consider. And we're seeing this, quite a bit at the moment with regards to EU children in care, where, immigration status and nationality hasn't necessarily been established. And, I think a lot of local authorities in the UK are scrambling to meet the EU settlement scheme deadline and ensure those immigration issues are sorted out before the deadline passes. Finally, consideration should be given with regards to how contact between the child and the child's existing family and friends network is managed. And a good transition plan should indicate who the child should continue to maintain contact with, in what manner this should happen, how frequently, etc. It's interesting. Right, so in terms of resources for international cases, I've got a couple of different resources to share with you. Obviously, we're here. ICACU is the central authority, no longer for England and Wales, because the UK is no longer part of Brussels II, but they are the central authority for England under Hague Convention 1996. Consulates are a great source of support and knowledge, I think, in any country. Child Helpline, Interpol, Europol, Criminal Records Office. These are more UK-based organizations, but they may still be of interest to you. We see in the UK, we see quite a lot of advice line calls around Polish family members and Roma as well, so that can be helpful. And then finally, I promised to put our advice line up there. Hopefully you can see that. As I mentioned earlier, we take calls from, social workers, from lawyers, from health professionals within the UK and outside of the UK. It's a free advice line. It's staffed by UK qualified social workers, and they're there to help problem solve and signpost onto other organizations if necessary. So please don't hesitate to give them a call if you've got any questions, or if you can't find something on our website and are trying to download our International Kinship Care Guide, for example. I'm very happy to help. You can visit our website, email us. I've got our email address up there. We're on Facebook and Twitter, so please do get in touch with us and follow us. Happy to connect. And I'm very happy to take any questions now, or to troubleshoot any challenges that people have found, and have a general discussion.
Thank you, Carolyn, for sharing such an important information with us here. And I invite all the people who are now in the room to share if they have any kind of questions or comments in the chat. I especially remember this part about these fantastic tools that you have on your webpage. I think it's really great that all of the countries who don't have these protocols defined so seriously, so I would say, so with such responsibility to use it as a good tool for themselves and to advocate for better protection of children. And I would say that during your presentation, I felt really like that you stressed the whole responsibility of all professionals who are included in this process to provide safety to children, a safe environment, and also to protect them from traumatization and re-traumatization, because I believe that this is the idea of the care for the children who are removed for their primary family, and then and I believe that this is the part where all the professionals need to be very cautious about it. Yes. So thank you for sharing all of this information with us. Yes. Okay, if there are no questions and no comments, I would just like to aim that this video will be uploaded to YouTube, and all of your data that you share in the PowerPoint presentation will be visible on the recording, and I believe that it's also okay for the professionals who will be watching the recording to contact with you.
Absolutely.
Okay.
Very happy to help.
Okay, so just the final note from me before I close the webinar. For all of these people who are with us here today, you can get a certificate of attendance of this to this webinar. You will need to send an email. I will write it in the chat. You send an email to this email in the chat, of course, and you will get a certificate in a few days. So thank you very much, Caroline, again, for sharing your time from your busy schedules to being with us today. I really wish you the best in your professional life. I really hope that we will be in contact in the future, maybe through the Child Hub or some other project.
Absolutely. Well, thank you for having me, and it was really a pleasure.
Thank
Best
you.
of luck to everyone.
Thank you. Goodbye, everybody.
Bye-bye.